All right, thanks for clicking there. I am Mike Hartmann, and we are going to talk today with Benjamin Leff, who is a professor at the American University Washington College of Law. He has several areas of specialization, but they include nonprofit law and philanthropy. Uh, Professor Leff has practiced law and clerked for a federal judge. But for our purposes, he is the author, I'll say most recently, of a paper that he wrote and published called Getting Donor Advised Funds Regulation Right, Closing the Public Support Test Loophole. So why don't we go to Professor Leff's Nonprofit Law 101 and just ask to start, I think probably necessarily, what's the public support test?
Excellent. So let me just back up for a second before I answer this question and just want to say you referenced that my article is published. It's actually not published yet. So I don't know whether your listeners are the kind of people who like to give feedback to people, but there's still time for me both to incorporate feedback and even to, there still is a little time even to explore other issues. So I just want to invite, this is like a very rich time when you have a draft paper and you can continue to hear from people their experiences or why they think what you're saying is wrong. Either way,
Careful what you wish for there.
I
Okay.
invite that feedback.
Yeah. And
So
I'll read it to the SSRN paper
great,
on which
thank you.
comment. Okay.
Excellent. Okay, so the public support test is the fundamental way that Congress enacted into law a way to distinguish between private foundations and public charities. And, you know, simplifying a little bit, basically, the public support test says that if you have multiple unrelated donors, then you're a public charity. And if you don't have multiple unrelated donors, then you're a private foundation. So that's a simplification, but fundamentally, it's the way that Congress divided the world of charities into two camps. And they did that specifically to apply a stricter regulatory regime to private foundations. And it's built on this theory that having multiple unrelated donors is itself a check on the organizations. It's kind of rooted to what is kind of the deepest or most accepted theoretical foundation of why we regulate and how we should regulate nonprofit organizations. And it's related to this presumption or belief that having multiple unrelated donors means that there are people who are interested in the organization advancing its charitable purposes. If you don't have those, if you kind of have especially if you have a unanimity of donors and control, so your board is controlled by the same people who give all the money, who are also the people who hire the director, all of that unanimity of control, lack of other stakeholders creates the opportunity of various types of abuse, most centrally kind of self-dealing kinds of abuse. And so we need a stricter regulatory regime to deal with that issue.
Mm-hmm. And I'm just restating but the corollary would be if you want to avoid those stricter conditions on the benefit of exemption, you have to prove more support than just from one rich person.
Exactly. Multiple unrelated donors. When I was in practice and I thought sometimes about how to describe to potential people who are thinking like, should I set up a private foundation or not? I used to describe the public support test just because of the way the math works, which is much more complicated math than we need to go into. If you can get 17 unrelated people to give about the same amount of money to an organization, you've got a public charity. But if you can't, then it's harder to pass the public support test. So,
And if I'm a nonprofit that, I don't know if the term is violated, but doesn't pass the public support test, what happens? Do I pay more taxes? Do they push me into the private foundation
yeah,
category? What's the penalty for
the
not?
penalty for failing the public support test over time. So the initial determination is made at the beginning of the organization, and it's most usual for this determination to be made at the beginning. In other words, it is rare for an organization that has been passing the public support test later to start failing it. But the penalty for failing multiple times over a period of time is that you would be reclassified as a private foundation.
Mhm. We, when
And
I
then the private, I mean, the details of what it means to be a private foundation are relatively complicated. There are situations in which you could have a tax burden associated with that. There's a very, very small excise tax on your investment earnings when you're a private foundation that public charities aren't subject to. But it's small enough that I don't think that's the primary thing that is driving people to want to be in one camp or another. And we can get in later when we get into, well, what's the regulatory regime for donor advised funds, which borrows some for private foundations, borrows some from public charities, and then has some of its own things. We can get into some of the details of what are the benefits and costs of the trade-off between private foundation and public charity.
So I worked on the program staff of a foundation, which was of some size, and we would sometimes be concerned about what we called tipping a grant recipient uh, beyond the point where they could satisfy the tag, give them
Yeah,
too much love in the form of money.
yeah,
And as a self-protective, had the law degree, but I wasn't on any legal staff or anything like that. And I would say to the legal people and accountants, well, that's not our job to worry about tipping, it's theirs.
yeah,
Why are we concerned about this?
right.
So that's a little provincial, to
Yeah.
the program. But was I right about that? Who's responsible for keeping track of whether the public support test is our private foundation funders? Is it incumbent upon them to make sure they don't tip a grantee, or is it the
I
grantee?
mean, you may know more than I'm now answering. And I tell my students when I'm telling them legal things that everything I say probably would be malpractice if it was legal advice, because I'm about to answer a question.
Yeah.
If you were my client, I would be like, huh, I better really be sure I know about that. But I know of no legal reason why the funder needs to care about whether they're tipping, except that their grants to private foundations don't count, and their grants to public charities is. So they're invested in their recipient being a public charity, but I don't think that would create a legal obligation. On the other hand, the relationship, as you know way, way better than me, the relationship between foundation donors and recipients sometimes relies on the legal expertise of the donor, just because often they have better access to good legal advice than the recipient. And so private foundations, I think, as a prudential matter, might really think that they're value added if they provide their recipient with legal analysis of exactly this kind of thing, which can be complicated.
Yeah. How long has the public support test been around? When was it born?
So they're actually starting in 1950. There were pieces of legislation that distinguished between public charities and private foundations, or created a new class of charities without using that vocabulary, that effectively became private foundations. But it really was 1969. In 1969, Congress held a whole bunch of hearings that were very, very critical of some of the things that were going on in private foundations. Some of it, I think, was like the bad kind of politics, if there's such a thing as the good kind of politics. But some of it was really concern about abuses that were going on in the private foundation sector. And they crafted what I think you have referenced, that I have referenced, that has been called this grand bargain, this set of tighter restrictions on private foundations. And the public support test, again, is a key component of how you know who falls into that category of private foundations, and therefore is subject to this tighter set of regulations.
And how do DAFs, I guess DAF providers, DAF accounts, DAFs in general, how do they frustrate the purpose of that law?
Great. So the way that DAFs, donor advised funds, are structured, they have some of the benefits of a private foundation. If you think of the benefit of a private foundation, is you can make a donation to charity, and it's a full donation. When it's not your money anymore, you have donated to charity when you give to the private foundation. But then most private foundations then use an endowment or a set of money, and they over time distribute that to charities. So you have this ability to kind of create a enduring institution that later makes distributions to other charities. So DAFs do that on a kind of smaller scale, and they themselves don't count as private foundations, because of the public support test. And the reason a DAF doesn't count as a private foundation is because a DAF is not a separate legal entity. A DAF is a fund that is held by a much larger legal entity, usually called the sponsor or the sponsoring organization. And the sponsor has lots and lots of DAFs. And so it's getting lots and lots of contributions from unrelated people. So it's a public charity. So it used to be, DAFs kind of developed slowly over a long period of time and mainly in community foundations. And then really big financial services companies, the first one was Fidelity, thought, oh my God, this would be a huge benefit for our clients and therefore for us. Let's create our own charity to hold people's DAFs. And then let's market it to our clients. If you want to give to charity, here's the easiest way to give to charity. And especially if you want to give the assets that you hold with us, your investment portfolio, if you want to give those assets to charity, give it through this DAF that we've created, DAF sponsor that we've created. So DAF sponsors are public charities and avoid all of the rules on private foundations. But in 2006, Congress, after not as robust criticism as way back in 1969, but Congress, there was some alarms that DAFs were being used to avoid the private foundation restrictions in ways that seemed abusive. And so Congress passed for the first time, a special regulatory regime for donor advised funds. It's the first time the phrase donor advised fund showed up in the tax code. And in 2006, in the Pension Protection Act, Congress created this regulatory regime for DAFs. So that regulatory regime, it didn't just say DAFs are private foundations, or it didn't just say you should apply the public support test on a fund by fund basis or something like that. In some ways, that would have been really simple. Instead, it maintained the public charity status of DAF sponsors, and then it enacted a series of provisions that in some cases applied the same rules that apply to private foundations to the donor advised fund, to the fund itself. In other cases, it actually created an even more strict regulatory regime for the fund being, the donor advised fund, the fund being held by the sponsoring organization.
The
And
large
then in some
body of
cases,
money, right? Not an account,
this
I guess.
this
Right.
pot of this account, it's an account. It's a yeah.
Yeah.
And then in some cases, it permitted these accounts and the sponsoring organization the same benefits that public charities have. And some of those benefits are pretty substantial benefits. So it created this hybrid regime where it's applying a set of different standards to different components and kind of pulling apart what is it doing? What is the implication of what it's doing? And is that good or bad policy? Or what's the effect of that? That's really the impulse of this paper is actually a kind of small part of that. The public support test loophole, though, the real flaw that the paper is talking about is this, that while the DAF is subject to, in some cases, higher regulatory requirements than the private foundation, under current law, if you give money to a DAF, the DAF is held by the sponsor, it's a public charity, but the sponsor is willing to distribute the money out to a charity that you create. Or to any charity, including a charity that you create. So if I, Ben Leff, create a charity called like the Ben Leff charity, and I donate money, if I were to donate money directly to it, I'm the only donor, I give it $1 million, it would be a private foundation. But if instead I just donate the money to the donor advised fund, and then I say to the donor advised fund, hey, will you distribute that money out to the Ben Leff fund? And it does it. And it can take literally 2 minutes. I could donate it and in the same breath say, hey, distribute 100% of the money I just gave to you out to the Ben Leff fund. Now the Ben Leff fund has $1 million. It came right from me. It didn't come from anyone else. And under current law, that would be a public charity, not a private foundation. So it's like a bounce pass or a conduit or a loophole. That structure, the fact that under current law, you can create a charity, which really in principle and under prior law really should be a private foundation, but is not because of this weird unintended use of the donor advised fund. That's the big flaw that I'm identifying in the paper.
Unintended use, you say, but let's impute ill motive. on the part of the person who wants to
Yes.
create
So
essentially a false
right.
vision of a false portrayal of public support for a group.
Right, right. And honestly, when I said unintended, I actually was imputing a motive to Congress. I was thinking
Yes,
like, oh,
yeah,
when Congress passed this act in 2006, they just didn't think of this, and so they didn't close it. Now, I don't know, it's a dangerous game imputing a motive to Congress because Congress isn't a
yeah,
thing or a person. It doesn't have motives in the same way. But it's hard for me to believe that if someone had said to the drafters of the 2006 Pension Protection Act, given the strong intention of that act, which was to recognize that there are opportunities for self-dealing and other kinds of abuse, well, those opportunities are viewed even more so if you bounce pass into this entity that you control. The idea that they would think like, no, that's cool, we want that, seems very unlikely to me. So that was the unintended.
yeah,
So there is an open question, and it's hard for me to convey how sincerely I mean this. I don't know how much this strategy is being used for the purposes of, the kind of the ultimate abusive purpose would really primarily be to use this entity to engage in some kind of self-dealing. There are other things that you could use this entity for. For example, if you want to if you want to use your entity for political ends, private foundations are much more restricted than public charities in what kinds of political spending they can do. And that's especially true when you add a 501c4 organization to the mix. So if I bounce pass into a public charity and then that public charity makes grants to a 501c4 organization, it would be much more restricted in how it did that if it was a private foundation making those grants than if it's this public charity. So there's lots of opportunities for abusive use. I don't know. I don't do empirical work, unfortunately. And so I don't have a method for trying to determine how much is this being used and especially how much is it being used for the most abusive types of uses. And there certainly is the case that it is also being used for uses that are not kind of insidious at all. And I'll even give you an example from literally my own life. So I, with some people who are graduates of my college and share interests, we actually created this micro charity. It's the smallest charity. We raise very little money in it and use it for like a variety of totally beneficial uses related to our alumni stuff. But it's easier to use our own charity than to give money to the school and deal with it. Anyway, I
yeah.
hope that I'm not going to even say what college I go to. But so we created this micro organization, and then I'm the secretary of this organization. I largely, with these other people, control this organization. And I wanted to get money into this organization. I actually my wife and I make the majority of our contributions, not all, but the majority of our contributions through a donor advised fund that's held at a community foundation. So I directed the community foundation to make a distribution to this charity. And then I realized, oh, this is going to look like an
Yeah.
abusive use. It wouldn't have made us fail the public support test, but just a fewer donors other than me, and it would have. I mean, this is a tiny organization. It's like doesn't have a lot of donors. It wouldn't be hard for us to fail the public support test. And so I called them and I said, hey, I'm doing this weird thing. I'm asking you to make a contribution from me to this tiny charity. And I'm the secretary of the charity. Does that give you pause? And they said, no, that's fine. We don't care about
Yeah.
that. So that would have been a totally innocent use. And there might be some of those floating around out there. And you wouldn't want to create a regulatory regime that created very high costs, either in compliance or for those kind of innocent footfalls.
Right. You do use the term in your paper, plausibly more sinister expert.
Plausibly more sinister. That's my
I
language
want
to
to
try.
drag you into the, cynicism or whatever, the
Right.
cynicism about sinister stuff.
Right. Exactly.
It's
Exactly.
reasonable to conclude that some of this is going on, whether immeasurable or not. I mean,
Exactly.
okay.
It's kind of like, I mean, I think the common sense of it is good enough without having to impute motives to any particular philanthropist. Like, I don't have great evidence of a sinister user.
Yeah.
And it's not really that important when you have such a basic flaw in the regulatory regime that creates the opportunity for abuse, it would be great if I had good evidence of how widely it's being used and how much abuse is being caused. But it's not necessary to understand that we have a regulatory flaw.